Queensland tenancy laws will be changing from the 1st of October 2022. This presentation is an overview of the changes and touches on the domestic and family violence protections introduced in October 2021. Also in October 2021, the following amendments were made to the Residential Tenancies and Rooming Accommodation Act 2008 and other legislation. The following are 4 key areas for the Stage 1 amendments and a few others to follow. Stage 2 is yet to be announced in full. The domestic and family violence provisions have been in place since 2021, and I'll summarise on the legislation surrounding those affected by domestic and family violence. Tenants experiencing domestic and family violence can end their interest in the tenancy giving 7 days notice, but can vacate immediately, and they can request their bond contribution to be refunded and are not liable for reletting costs and for property damage caused by the domestic and family violence they experienced. If they're staying, they can change the locks or access codes without requiring the landlord's consent to ensure their safety. The vacating tenant will need to provide the landlord with the new form for ending their interest in the tenancy. They must be able to provide relevant evidence like a protection order or a domestic violence report. Domestic violence report can be reported by a health practitioner, a support professional, a crisis worker, solicitor, or a social worker. If the landlord doesn't agree, it won't be an option to simply say no. The matter must proceed through QCAT with this notice within 7 days. There is a strict time period and process that must be followed once the notice period has been issued, with confidentiality and safety as a priority. There are still negotiations required around renting with a pet. A tenant must still apply to keep a pet, and the consent by the landlord is subject to identified reasonable grounds within 14 days. Any pet damage will not be considered fair wear and tear. Conditions may be that the pet must be kept outside. Carpet cleaning and pest control clauses can be inserted into the agreement. However, you cannot ask for a pet bond or increase the rent to allow a pet. These are the reasonable grounds to refuse a pet. Exceeds a reasonable number of animals kept at the property. The premises is unsuitable, like due to lack of appropriate fencing. Likely to cause damage that could not practicably be repaired for a cost less than the bond amount. A risk to the health and safety of a person. The tenant does not agree to reasonable conditions, and it contravenes a law or a body corporate bylaw. There is a defined description between a working dog and a pet. A working dog must have a certificate or permit. A pet is considered a domestic animal and is all other animals without a certificate or a pet. Working dogs does not require landlord's approval in accordance with the Guide, Hearing and Assistance Dogs Act 2009, Corrective Services Act 2006, and Police Powers and Responsibilities Act 2000. If a working dog is at the premises, the agreement will exclude pest control and carpet cleaning. There has been some controversy surrounding the ending of a tenancy and the removal of the without grounds option. The term without grounds applied to fixed and periodic tenancies. In its place, however, the option to end a fixed term agreement has been inserted. This gives the option to end a fixed agreement with a tenant who may not be suitable for the property or any other approved reasons to take back the possession of the property. The other reasons are undertake significant repair or renovation, the change of use, the landlord or their relative moving in, the sale or the preparation of a rental property for sale requiring vacant possession. A new reason for ending the tenancy is an application to tribunal to terminate the agreement for a serious breach. Clarification around a serious breach is noted on the slide. Our concern for this reason is that it may place the property manager or the landlord in danger either attempting to negotiate with the tenant or having the right evidence to substantiate this type of a serious breach. There will be more to come on this at a later time. Tenants will have the grounds to end the tenancy and vacate the property, where the property is not in good repair and evidence must be provided within 7 days of the commencement of the tenancy. Further, clarification has been established for the existing tenant to give notice to vacate after the death of a co-tenant. This will not be considered a break lease situation. There will be the option for the tenant to apply to tribunal within 3 months of the commencement of the tenancy to terminate the agreement due to misrepresentation by the landlord or the agent. This could be failure to disclose due to an event at the property, or for an order to set aside the landlord's actions if the tenant reasonably believes retaliatory action has been taken against them. Retaliatory action is where the tenant believes they have been given a breach notice or ending a fixed term agreement by the landlord for things like reporting repairs or other areas they believe they are being punished. Ending a periodic tenancy. Remembering that ending a periodic tenancy without grounds has been removed, we have always encouraged landlords to maintain a fixed term agreement. This allows the landlord more control and certainty over the tenancy and benefit any landlord insurance policy in place. A periodic tenancy is where the lease agreement has passed its end date and automatically falls into a periodic lease should the lease not be formally ended. The new legislation will not allow an end to the tenancy for no reason other than the prescribed reasons. That means if the tenant is not suitable for the property, the option to provide notice without grounds no longer applies. I have placed this slide in the presentation as a caution to the landlords to ensure that the reasons to end a tenancy, other than a fixed term tenancy, have evidence to back them up. Clarification around some of the reasons for reletting requires further details by the Residential Tenancies Authority. At the moment, the premises cannot be relet for 6 months after the tenancy has ended. And to be very mindful that penalties will apply, and they are quite significant. The minimum housing standards was an amendment that was passed in 2017. However, it had not been finalised. It has 2 categories. One is safety and security, and the other is functionality. New laws for minimum housing standards are not currently in effect. They're due to commence for all new tenancies on the 1st of September 2023 and for all other tenancies 1st of September 2024. Section 185 of the Residential Tenancies Act, Lessor's General Obligation, continues to apply to repairs, fit and clean to live in and not in breach of any health and safety laws. Repairs and maintenance must continue. New laws for the minimum housing standards will include, but not limited to, weatherproof and structurally sound, fixtures and fittings in good repair and not likely to cause injury, locks on doors and windows, free of vermin, damp and mould, privacy coverings, adequate plumbing and drainage, and functioning kitchen and laundry facilities. It is mostly standard for a home, but minimum housing standards have placed clarification around several areas. There are several other amendments that are important, but not one of the major changes, and I will explain these amendments in a separate presentation. Finally, to break it down into bite-sized pieces, this presentation is an overview of the changes to be implemented on the 1st of October 2022. Each topic on the major changes to the tenancy legislation will have its own presentation with more details surrounding the change. Bell Property staff have received extensive training on what's to come. However, until it's in play, there are some questions that we may need to clarify in the early stages.